Imagine you're driving home after a long shift at work. The roads are empty and the radio is low. You're not speeding and you're not under the influence. Suddenly, you see those red and blue lights flash in your rearview mirror. Your heart instantly drops into your stomach. Your palms start sweating on the steering wheel even though you know you have done nothing wrong. This is a physiological response that happens to almost everyone. But what you do in the next few minutes could change the entire trajectory of your life. It could mean the difference between a warning and a criminal record. It could mean the difference between going home to your family or spending the night in a cell. My name is Sarah. I have over 15 years of experience working with constitutional rights and criminal procedure. Today, we are going to walk through a realistic traffic stop scenario to teach you 10 critical rights. This is not legal advice for your specific case, but rather an educational guide to help you understand the law. Let me tell you about a driver named Elias. Elias is 24 years old and drives a 10-year-old sedan that has seen better days. He's nervous because he's never been pulled over before. He sees the lights and immediately pulls over to the shoulder. He puts the car in park and waits. The first thing Elias does wrong happens before the officer even approaches the window. Elias starts digging around in his glove box to find his registration. He's moving his shoulders and reaching across the passenger seat. To a police officer approaching from behind, this looks like he is either hiding contraband or reaching for a weapon. This is our first lesson in officer safety and situational awareness. The best thing Elias can do is turn off the car and turn on the interior dome light if it is dark. He should roll down the window and place his hands clearly on the top of the steering wheel. This simple act de-escalates the tension immediately. Now the officer is at the window. The officer shines a flashlight directly into Elias's eyes and asks for license and registration. Elias hands them over with shaking hands. Then the officer asks a very common question. He says, "Do you know why I pulled you over tonight?" Elias thinks he's being helpful and honest. He says, "Well, maybe I was going a little over the speed limit back there." Elias just made a critical error that brings us to right number one. Right number one is the right to remain silent under the Fifth Amendment. You have likely heard the phrase, "Anything you say can and will be used against you." That doesn't just apply after you are arrested. It applies the moment the encounter begins. By guessing that he was speeding, Elias just confessed to a traffic infraction on body camera. The officer now has an admission of guilt that can be used in court. The better answer is a polite, "I would prefer not to guess, officer," or simply a respectful, "No, sir, I do not." You do not have to lie, but you never have to help the government build a case against you. The officer looks at Elias's license and then looks at the back seat. He sees a backpack and some gym clothes. Then the officer gives a command that surprises Elias. He says, "Step out of the vehicle for me, please." Elias freezes and grips the steering wheel tight. He remembers reading something online that says he doesn't have to get out of his car for a simple ticket. So Elias says, "I'm not comfortable doing that, and I'm going to stay right here." This brings us to right number two, which is a massive misconception. This is the rule established in the Supreme Court case Pennsylvania versus Mims. In 1977, the Supreme Court ruled that for officer safety, police can order a driver out of the vehicle during a lawful traffic stop. They do not need probable cause to do this. They do not need a warrant to do this. They simply need to have you lawfully detained for the traffic violation. If Elias refuses this lawful order, he can be arrested for obstruction or resisting a lawful command. Civilians often confuse their home rights with their vehicle rights. You do not have to open your door for police at your house without a warrant, generally speaking, but on a public road, the rules of Pennsylvania versus Mims apply. Elias eventually complies and steps out of the vehicle. He is standing on the side of the highway now and feels very vulnerable. The officer separates him from his car and stands between him and the door. Now the officer starts asking more questions. He asks, Where are you coming from, and where are you headed? He asks if there is anything illegal in the car he should know about. Elias says, I'm just coming from my friend Sarah's house, and we were watching movies. Now the officer has a timeline and a location to verify. If the officer suspects Elias is lying, he can catch him in a contradiction later. This is why we go back to right number 1. You can politely decline to answer questions about your day. You can say, Officer, I'm not discussing my day. I would just like my citation, please. This is not being rude. It is being smart. The officer looks at Elias and says, well, if you have nothing to hide, you won't mind if I take a quick look in the trunk. Elias feels pressure because the officer is standing right over him. He thinks if he says no, the officer will think he's guilty. So Elias says, sure, go ahead. This is right number 3, and it is arguably the most important one. Right number 3 is the right to refuse consent to search. The Fourth Amendment protects you against unreasonable searches and seizures. However, that protection disappears the moment you give voluntary consent. Courts have ruled that if you say yes, you have waived your Fourth Amendment right for that search. Officers are trained to ask for consent in a casual way that sounds like a command. They might say, pop the trunk for me real quick. Or they might say, you don't have any rocket launchers in there, do you mind if I check? Elias should have said, I do not consent to any searches. This must be said clearly and unequivocally. Saying, I guess so, or, well, if you have to, is often interpreted as consent. If Elias refuses consent, the officer needs probable cause to search the car without a warrant. Probable cause is a specific legal term. It means there are facts or evidence that would lead a reasonable person to believe a crime has been committed. A hunch is not probable cause. Nervousness is generally not probable cause. But because Elias said yes, the officer is now digging through his gym bag. Let's rewind and pretend Elias did not give consent. The officer is standing by the window and shines his light into the back seat. He sees a clear plastic baggie with white powder on the floorboard. This brings us to right number 4, which is the plain view doctrine. If an officer is in a place he's legally allowed to be, he can seize evidence of a crime that is clearly visible. This includes looking through your windows. If Elias leaves illegal items on his passenger seat, he has no expectation of privacy for those items. This is why keeping your car clean is actually a legal defense strategy. The officer sees nothing illegal in plain view, but now he wants to extend the stop. He goes back to his cruiser and sits there for 15 minutes. Elias is standing outside or sitting in his car waiting. He's wondering how long this can legally take. This brings us to right number 5, which comes from the Rodriguez versus United States case. In 2015, the Supreme Court ruled that a traffic stop cannot last longer than the time reasonably required to address the traffic violation. Police cannot extend the stop just to wait for a drug-sniffing dog to arrive unless they have reasonable suspicion of a new crime. If the officer has written the ticket and checked the license, the stop must end. If Elias sits there silently, he's wasting his own time. He needs to trigger the end of the interaction. This leads to right number 6, which is the magic question. Elias should ask, am I free to go? This question forces the officer to clarify the legal status of the encounter. If the officer says yes, then Elias should leave immediately and calmly. If the officer says no, then he's being detained. If he's detained, he should ask why. If the officer cannot articulate a reason for the continued detention beyond the traffic ticket, he may be violating the Rodriguez ruling. Let's complicate the story. Imagine Elias has a passenger named Sarah in the car. The officer asks Sarah for her ID as well. Sarah asks if she has to. This brings us to right number 7, which is passenger rights under Brendlin versus California. The Supreme Court held that passengers are also seized during a traffic stop. This means they have standing to challenge the legality of the stop in court. However, whether a passenger must identify themselves varies by state. In some states, passengers are not required to provide ID unless there is independent reasonable suspicion they committed a crime. In other states, failure to identify can be an obstruction charge. This is where you must know your specific local laws. But generally, passengers have the right to remain silent, just like the driver. Let's go back to Elias. The officer suspects Elias might be impaired because his eyes are red. Elias admits he's tired, but the officer wants to be sure. The officer asks Elias to follow his pen with his eyes. This is the horizontal gaze nystagmus test. Then he asks Elias to walk a straight line and turn. This brings us to right number 8, which is the right to refuse field sobriety tests. In most states, the roadside physical agility tests are voluntary. These are different from the chemical breathalyzer test you take at the station after an arrest. The roadside tests are designed for you to fail. They are subjective and depend on the officer's interpretation. Unless you are in a state with specific penalties for refusing the field tests, you can typically politely decline. You can say, "Officer, I am willing to take a chemical test at the station, but I will not perform roadside agility tests." Be aware that refusing might give the officer a reason to arrest you based on his other observations, but you are not providing him with more evidence of you stumbling or losing balance. Elias decides to do the tests, and he is so nervous he wobbles. Now the officer has more ammunition. While all of this is happening, Elias wants to document what is going on. He pulls out his smartphone and starts recording the officer. The officer tells him to put the phone away. This brings us to right number 9, the right to record. Under the First Amendment, you generally have the right to record police officers in public performing their duties. This has been upheld in multiple federal circuit courts. However, there are reasonable restrictions. You cannot interfere with the officer's work. You cannot shove the phone in his face. You cannot physically obstruct him. Elias should hold the phone steadily at a safe distance or place it on the dashboard. If the officer orders him to stop recording, Elias can politely state, "I am exercising my First Amendment right to document this encounter." If the officer arrests him for it, that arrest may later be deemed unlawful and could be the grounds for a lawsuit. Finally, the situation escalates and the officer decides to write Elias a citation for a broken taillight. Elias is angry because he thinks the stop was unfair. The officer hands him the pen to sign the ticket. Elias thinks about refusing to sign. This brings us to right number 10, which is understanding the signature. Signing a traffic ticket is not an admission of guilt. It is simply a promise to appear in court or pay the fine. Refusing to sign the ticket, in many states, is an arrestable offense. You can be taken to jail simply for not signing the piece of paper. It is never worth going to jail over a signature. Take the ticket and fight it in court later. The side of the road is not the place to litigate your case. The side of the road is for survival and silence. The courtroom is for arguments and evidence. So let's recap the scenario with Elias. He should have pulled over safely and turned on his interior light. He should have kept his hands on the wheel. He should have politely refused to answer where he was going. He should have complied with the order to step out under MIMS. He should have clearly refused consent to search his vehicle. He should have asked if he was free to go once the ticket was written. He should have known he could likely refuse the roadside gymnastics. He should have signed the ticket without argument. If he had done these things, the encounter would have been shorter and safer. One final note on the legal term reasonable suspicion. This is a lower standard than probable cause. Reasonable suspicion is all an officer needs to pull you over and briefly detain you. It means they have a specific, articulable reason to suspect criminal activity. A broken taillight is enough. Swerving within your lane is enough. But a hunch or a gut feeling is not enough. If you are ever in doubt about whether your rights were violated, write down everything immediately after the stop. Write down the officer's badge number and the time of day. Write down exactly what was said. This contemporaneous record will be invaluable to your lawyer later. Remember that laws change and they vary by state. In 2025, we are seeing increased enforcement of speeding in school zones and stricter penalties for distracted driving. Some states are implementing new laws regarding what officers can say at the start of a stop. For example, California's new laws aim to prevent pretextual stops by requiring officers to state the reason for the stop before asking questions. Stay updated on your local statutes. Your knowledge is your shield. Being polite does not mean being submissive. You can be respectful while still firmly asserting your constitutional rights. Officers are professionals doing a dangerous job, and they respect clear, calm boundaries. If you escalate or get aggressive, you lose the upper hand. If you remain calm and silent, you maintain control of your legal future. I hope this walkthrough helps you feel more prepared for that moment when the lights flash behind you. Drive safe and know your rights.